It's time again for Legal Talk right here on eRadio, and last week we spoke about all things to do with commercial and residential rentals and what to do in the time where it's a bit difficult to pay the money. But this week we are talking about all things to do with the Consumer Protection Act and your right to return goods. And joining us from Hahn and Hahn Attorneys is Janusz Luturek. A very big hello to you, Janusz. How's it going?
Hey, it's going well here. The sun is out sort of for a while, and things are good here in town. Thank you.
Okay, well, we've got Noah's Ark right here.
Ready to go.
Ready to go, yes. Okay, so this week we're talking about the consumer's right to return goods, but let's just go back and talk about the Consumer Protection Act, also referred to as the CPA. And can you tell us when it came into law?
Yes, so many consumers might be surprised to find that this law actually came into effect in 2008 and was fully in effect with regulations by 2009. And the reason why they might be surprised, because there are still businesses today that don't seem to be aware of the rights consumers have under this law.
And Janusz, can you some people talk about a consumer's bill of rights. Can you give us some examples of these rights?
Sure. So the Consumer Protection Act created a lot of rights for consumers, which consumers may have had to some extent before. And I think generally, if you shopped at big reputable shops, they would meet you at this point as well anyway. But now these rights are available to everyone. And what the first most important right is that a consumer has the right to information. So they have the right to know what it is that they are buying. And very importantly, it has to be provided to them in plain and understandable language. Now, you may ask, what does that mean? But what it means is that where a consumer is a maybe uneducated consumer and they are the target market, then you can't be using medical terms and scientific terms when you are trying to convince them to buy the product. You have to speak to the consumer at the level that the consumer understands. Another very important right in the Bill of Rights, and that's really where the topic of today's discussion is that consumers got a lot of rights to return goods when the goods didn't meet the expectation, or they weren't correct, or they were faulty or defective, etc. But one thing that consumers must understand, there's no absolute right to return. And I will talk about that later. There isn't this absolute right, I just want to take it back. What reason? No reason. There was supermarkets and big retailers that do allow you to return goods within 15 days of purchase, but that's not because of the Consumer Protection Act. That's because of their own internal policies. So another important right that consumers have got under the Consumer Protection Act is to claim for damages if they suffer any harm in any way from goods that they have purchased. So if the goods fail, or they're defective, or in any way harmful, then the consumer can claim against the supplier, and that can be the retailer, the manufacturer, the importer, and they can't rely on a defense which says, oh, but I didn't know.
Okay, so let's say I buy goods at a store and I ask for delivery. And I mean, that's something we really do nowadays, especially since COVID. We even order our shopping online, and then they deliver it and it's not what I was told I was getting. What are my rights to refuse them and send them back for a refund? Let's say it has a stain on it or something.
Sure. So the Consumer Protection Act is very clear. And what it says is that when goods are delivered to you, and there's actually nothing wrong with them. It's not that it's broken or it doesn't work. But what the situation is that you've gone to the store and you've asked for a product, but you didn't have a chance to inspect it. Maybe there wasn't one in stock on that day or anything like that. Then when the goods are delivered, you have to be given the opportunity to examine them before you take them. And if you have not had that opportunity, or the goods are not the same as the ones that were in the brochure or the sample that was shown to you, or for example, they're not suitable for the purpose for which they were sold, then in those cases, within 10 days, 2 weeks, 10 days is two working weeks of it being delivered to you, you can return those goods. And they're not allowed to charge you anything except a restocking fee, which must be a reasonable amount. It can't be 50% of the value or 75% of the value. It would have to reflect the real cost of restocking the product. Now, there is one exception to this at the moment in South Africa, and that is medicine. You can't return medicine, and I think that's pretty obvious why that would be so. But very careful, if you alter anything that you've got, then you can't return it. So you can't receive something, you then decide, I need to mount it on the wall. And after you've mounted on the wall, you've had to screw something onto it or cut something off, and then you decide you want to return it. Because once you have altered it or disassembled it, your right to return it ends, except if it's defective, which we'll speak about a bit later.
Okay, well, that makes sense. Here's another scenario for you. What if I buy clothes and then when I get home, I realize that I don't look as good in them as I thought? Do I have the right to return them for a refund? I'm obviously not talking about underwear.
No, sure. No, exactly. But, this happens to me all the time. I buy clothes and in the shop, the lighting is different and there's someone there and they're telling you, this suits you so well, you look so good. But when you get home, it doesn't fit. Mm-hmm. The lighting is different. You're not looking at your best. Sadly, that is not a ground for returning it. So simply because you changed your mind doesn't grant you the right under the Consumer Protection Act to give it back. There was no deception. The goods you saw them, you tried them on, you had them in your hand, you put them on, you took them home. If you then decide you don't like it, bad luck for you. Depending on the shop you shopped at, some of them will allow you to bring it back. But that, dare I say it, is from the goodness of their heart. There's no legal requirement for them to take it back.
Okay. And yes, I still have a few scenarios for you. I hope you're ready. The next one is, let's say I get home and I find a delivery has been made to my house for a fridge, for example, and security or somebody signed for it. But I didn't order it and I wasn't expecting it. What do I do? Can I just keep it?
Well, this is a very interesting scenario because this is something I actually dealt with quite a number of years ago, and it actually happened. So in a town, there are two suburbs with the same street name. And the person goes to a big retailer and they order a fridge and they give the address. These companies outsource delivery, so the man comes along with his 1-ton bakkie or 1-ton truck, loads the fridge, he looks on Google Maps, he finds a street and he goes. He gets to where he thinks he should be delivering it, but obviously, who's at home? The only person that's at home is the housekeeper, the maid. She doesn't know if the owners of the house ordered a fridge or not, so she signs for it. They carry the fridge in, they put it in the middle of the kitchen. 5 o'clock, people come home from work, they arrive at home, by then the domestic is gone, and there's this fridge in the middle of the kitchen, and they think, oh my goodness, what's this? Where did it come from? And they find a piece of paper, and it's a retailer's name. It's not their name, but it looks like it's their address. So for the next couple of days, they start phoning this retailer, but the only number on the invoice is an 086 number. There's no number to the particular branch where this was purchased. And every time when they call the call center and they tell them their story, the people don't seem to understand. They think they're calling because their fridge wasn't delivered. And they promised to look into it. Now, the reality is that in terms of the Consumer Protection Act, once you've made the effort to notify the person who sent you the goods wrongly, and they don't come and fetch it within 1 month, well, it's actually the law says 20 working days, then it's yours to keep, mahala and for nothing.
Oh, nice.
So companies better be careful. But you would expect that somebody would have looked on the system because the person who should have got the fridge, you would imagine, would have been phoning and saying, where's my fridge?
Exactly.
So I don't know how this happened, that they never traced it. but they never did. And in fact, as far as I know, no one ever came to these people to ask them for the fridge.
So that's a true story, and those people
That's a true story.
They still have that fridge to this day. That's crazy. Wow.
But it can happen. But it can happen a lot with deliveries. Nowadays we're all getting boxes delivered by little guys on motorcycles.
Yep.
I don't know if that happens where you are.
Absolutely.
And I've had them come to me at the wrong address and try to give me something. So I think this can happen more often than one imagines.
Yeah, and then it's so interesting that you can keep it. But anyway, moving on to our next scenario. I'm actually having fun with all these scenarios. Right now, I go shopping for a bed, and I see ads promising all sorts of health benefits using medical terminology. For example, they say I will have 2 hours longer sleep with this bed and unreal comfort. But now I buy one of these beds and I get home, I then realize it's just an ordinary foam mattress bed and the claims made are probably not true. What does the CPA say about this?
So the Consumer Protection Act protects a consumer against false and misleading and deceptive advertising, claims which are made about products which are not true. And where these things happen, the consumer has the right to insist to return the product. So obviously, at the end of the day, some of these things are debatable. You can just imagine somebody says, well, you sleep 2 hours longer. And I say, no, I didn't. And they say, well, I can't help it that you're an insomniac. But there are clearly claims which are being made, which I've seen, which are so blatantly not true that they are easy to show to be false. And then those people are contravening the Consumer Protection Act in the way that they market the goods. Now, there is an alternative route that the consumer can follow. They can actually lodge a complaint with what's called the ARB, the Advertising Regulatory Board. But that's not going to get you your money back for the bed. The way to get your money back is through the CPA. You will threaten the seller. You'll say this bed isn't what you promised. You lied in your marketing and you made misleading representations. Take it back and give them the money back. Otherwise, I will go and lodge a complaint with the consumer protector.
Okay, so let's say I get the mattress and then I unwrap it and now I slept on it. And I'm not happy with it. Can the seller refuse my attempt to return it because I have unwrapped it and slept on it?
So this is interesting because some things you can't tell until you've actually unwrapped it and tried it.
Yeah.
A claim that it's more comfortable and it smells sweet or whatever, until you actually unwrap it and try to sleep one night on it, you wouldn't know.
Yeah.
So if the claim is misleading, and in fact what they said is not true, the fact that you had to test it out does not prevent you from returning it for a refund, but then it's got to be done within that reasonable period of 10 working days. So you can't keep it for 6 months or a year and then decide, actually, it's not as comfortable as you thought, I want to send it back. So these, let's call them soft issues. In other words, there's nothing wrong with the product. It's not broken. These are subjective. You have your 10-day period in which to return it.
Okay, now it gets interesting. I keep the bed, and after 3 months, the leg breaks and the wooden frame falls apart in the corner. I call the seller to return the bed. What are my rights right now?
So this is where the Consumer Protection Act gets really good for consumers. Every product sold in South Africa automatically has a 6-month warranty. You don't need the retailer to tell you comes with a warranty. Doesn't need to be a big sticker on it that says it comes with a warranty. If it's sold in South Africa, it has a minimum 6-month warranty. And during that 6-month period, if the product fails or breaks or turns out to be defective, as a consumer, you have the right to agree that they repair it for you, agree that they replace it for you, or demand a refund. Now, demand a refund would be in a case where it's not really repairable. The product is clearly now just ready to be thrown away. Where it's a minor defect and the leg broke and they can just bring another one and screw it in, you clearly can't demand a refund, but you can certainly demand that they repair it, and if they can't repair it, that they replace it. So that's a period of 6 months. You'll find products say on them 5-year warranty, 10-year warranty. After the 6-month period, they can say anything in their warranty they want. They can say you can only call them when the moon is full and there's an owl in the tree. And if they say that, then that's what it's going to be. But in the first 6 months, the Consumer Protection Act will apply, and you have the absolute right to return the product if it breaks or is defective in that period.
Now it gets even more complicated. I was on the bed and then I spilled some tea on it. Now there's a stain. Can this be a reason for them to refuse to take the bed back?
Okay, so there are two scenarios. If it's because you say the bed is not comfortable enough or something like that, but now you've stained it, you potentially have a problem, because now you should have been testing it, you should have been very careful, it should be kept in a condition where it could be returned. But where the scenario is that the leg broke and the frame is damaged, etc., the stain has nothing to do with that. Whether the stain was there or not, the bed broke. And therefore, it is not an excuse to say to you, you can't return it because now it has a stain. If the stain is not related to the actual cause of the bed being returned, it can be returned.
Can the retailer claim that as you sleep on a bed, then it's unhygienic to take it back, regardless of the reason?
No, they can't, because obviously a bed is something you sleep on, and then if it was poor quality or it broke or there was some other reason that you had to return it, there's no alternative. You had to sleep on it in order to know that there was something wrong with the bed. I mean, there are those examples where it arrives and you ordered the mauve one and they sent you an orange one. I mean, those obviously are maybe something different. But the fact that you slept on the bed and now it's broken and you want to return it is not a reason at all to reject it.
And guess what? It's getting even more complicated now. I fell off the bed when the leg broke and I hurt my neck. Do I now have a claim against the mattress seller? What about the manufacturer?
So as long as the mattress seller is not the importer, in other words, what the Consumer Protection Act says, there's always got to be somebody in South Africa that's responsible. The retailer can't say to you, this comes from Thailand, here's the address, tell the guy in Thailand about your saga with your bed and your neck. You sold it, you are the first point of call. If the manufacturer or the importer are also in South Africa, then in fact they may end up being liable if the defect was due to poor manufacture or they used wood which was eaten by beetles or something like that. Because the Consumer Protection Act says that the supplier, manufacturer, importer, there's another category, there's 4 categories, are all liable jointly for any harm that I suffer as a result of a failure or defect of a product. The only exception is if a retailer was unable to determine that something could have been wrong with the product using their normal common sense and normal skills and so on. So obviously, if the leg was already broken and they try to push it back together and give it to you, then they can't avoid liability. But there are some things that as a retailer, clearly they're not the manufacturer, they may not know that there was something wrong with the product. Then as long as they're not also the importer or the manufacturer, they could avoid being sued for your neck being sore, and then the manufacturer would step in and you would go after them.
Now, just before we wrap up, there's another spanner in the works. What if I weigh 150 kilograms and I'm 2 meters tall? Will that change the situation?
So I'm not quite 150, but I'm over the usual 100, and I'm not quite 2 meters tall, but I'm close to it. Mm-hmm. And actually, it's a big problem when you buy various types of things. For example, gym equipment. You know, they sell gym equipment, supposedly so that you can get fit and lose weight. But if you read the small print, it says for maximum weight 100 kilograms. People that weigh under 100 kilograms probably don't need the gym equipment.
Yeah.
So it's the same with the bed. You'll find a bed has a maximum weight rating. And then the bed might be only 1.8 meters long. So if I buy a bed which is rated at 120 kilograms, and I don't read the fine print, and I weigh 150 kilograms, and then after a couple of months, the bed develops a dent in the middle, you're not going to be able to return it because, in fact, you've abused the bed. You've used it outside the manufacturer's specifications. Now, There can be an argument. Maybe they should have brought to your attention. They saw you. You're a big guy. Sir, are you aware that this bed could not possibly hold your weight? But, presuming that there's some notice on the corner or a little circle which says 120 kilogram weight rating. And by the way, if you go to the big retailers and you look at the gym equipment, they all nowadays tell you what the maximum weight is of the person who can operate it.
Now, our very last scenario for today's legal talk. What if I put, I'm going to try not to laugh. What if I put the bed in my guest house and now the bed breaks with guests on it?
So, let's not go into what the guests might be doing when it broke.
We go.
But a lot of products that are sold in normal retail are for domestic use only. In other words, they're light duty. So if you buy something, and by the way, you see it a lot on appliances, you see it on power equipment, it will say in the ad, domestic use only. Very rarely there'll be one that says professional use. Now, as soon as I say professional use, I'm opening myself up as the manufacturer or the retailer, because it's expected to be able to work that much harder before it breaks. So if you buy something that's for domestic use only, and then you go and use it commercially, where it's obviously working much harder, there are different people using it every day and so on, you will not be able to claim, because in fact you have broken the rule which the manufacturer set, which was this is for domestic use only. So be very careful. If you're running a business, if you're a small contractor, you're a guy that puts in kitchen cupboards or does swimming pools, and you see an ad at one of the big retailers and you think, gee, that power tool looks really cheap, I'll go buy it. But it says domestic use only. And now after the fifth hole that you've drilled, the drill breaks, you're probably not going to be able to take it back, because they'll tell you, hang on, chap, you're not using it for domestic use. You're actually a builder. You should have bought the professional range. And the same would apply to this bed. If you've got a hotel, you need to buy the things that are made for use in a hotel.
This has been very, very interesting, Janusz. So thank you so much. I really enjoyed it, and thank you for your time and your knowledge. How do we get in touch with you?
So the easiest is at our firm, Hahn & Hahn, and on my email address, janus@hahnlaw.co.za. So it's my first name, Janusz, Janusz, @hahnlaw.co.za.
Excellent. Thank you so much. This has been very, very insightful. Until next time, keeping it legal.
Thank you very much. And stay warm and stay dry.
You too. Thank you.
Thanks.
Bye-bye.
Bye-bye. Bye. Bye.